Start. We heard Mr. Dhruv Mehta, Learned Senior Counsel for the appellant, and Mr. Amrendra Saran, Learned Senior Counsel for the respondent. Stop. Mr. Dhruv Mehta, Learned Senior Counsel, in his submissions, after drawing our attention to Section 69 and in particular Section 69(3) of the Partnership Act, contended that when subsections 1 and 2 are read into subsection 3 of Section 69, the expression other proceedings mentioned in the said subsection 3 should be with reference to other proceedings connected with a suit in a court and cannot be read in isolation. Stop. The Learned Senior Counsel contended that if it is read in that sense, the expression other proceedings in subsection 3 can have no relevance nor referable to arbitral proceedings in isolation. Stop. The Learned Senior Counsel further contended that going by the plain reading of the statute, and if the golden rule of construction is applied, an arbitrator by himself is not a court for the purpose of Section 69 of the statute. Stop. The Learned Senior Counsel then submitted that there is a vast difference between an arbitrator and the court, that though an arbitrator may exercise judicial powers, he does not derive such powers from the state, but by the agreement of the parties under a contract, and therefore he cannot be held to be a court for the purpose of Section 69 of the Partnership Act. Stop. While referring to Section 36 of the 1996 Act, the Learned Senior Counsel submitted that it is only a statutory fiction by which, for the purpose of enforcement, the award is deemed to be a decree, and it cannot be enlarged to an extent to mean that by virtue of the said award to be deemed as a decree, the arbitrator can be held to be a court. Stop. Lastly, it was contended by him that in order to invoke Section 69(3), three mandatory conditions are required to be fulfilled, namely that there should be a suit and the other proceedings should be intrinsically connected to the suit. Such suit should have been laid to enforce a right arising from the contract, and such a suit should have been filed in a court of law. Stop. Para. As against the above submissions, Mr. Saran, Learned Senior Counsel for the respondent, submitted that the expression other proceedings will include arbitral proceedings, and that the foundation for it must only be based on a right in a contract. Stop. In support of the said submission, Learned Senior Counsel contended that this court has held, while interpreting Section 14 of the Limitation Act, that arbitral proceedings are to be treated on par with civil proceedings. Stop. The Learned Senior Counsel also submitted that under Section 2(a) of the Interest Act, arbitral proceedings have been equated to regular suits, and therefore the expression other proceedings in Section 69(3) of the Partnership Act should be held to include an arbitral proceeding on par with a suit. Stop. The Learned Counsel therefore contended that the arbitrator should be held to be a court, and the proceedings pending before it are to be treated as a suit, and consequently other proceedings. Stop. By referring to Section 35 and 36 of the 1996 Act, where an award of the arbitrator has been equated to a degree of the court and applicability of civil procedure code for the purpose of execution has been prescribed, the learned senior counsel contended that the arbitral proceedings should be held to be civil proceedings before a court stop